Hey, hello everyone in family law. I thought I would do a fairly quick and hopefully concise review of Chapter 4 dealing with the law of divorce, annulment, and legal separation. Some people think of this as the heart and soul of family law because there aren't that many cases litigated about who can get married or who might be eligible to marry, who can object to marriage, things of that nature, although important, don't make up the day to day existence in a family law practitioner's daily routine. The paralegal, the legal secretary, the attorneys, they often deal with the big nugget issue of the breakup of the legal entity of marriage. And that's what chapter 4 is about. It's a very big chapter. I'm going to start off with the two narrower aspects of the dissolution, or at least the abeyance of marriage. What do I mean by abeyance? It means the marriage doesn't end. So we might as well start talking about legal separation. A lot of people believe that when you start a divorce proceeding, you are now legally separated. That's kind of inaccurate. You already have a right under Massachusetts law, and I believe everywhere in the United States of America, you have a right to physically separate yourself from your spouse if you're no longer comfortable living with them. That doesn't make you legally separated, nor does filing a complaint for a divorce. And while it's pending, because you usually don't get a divorce overnight, it takes some time to go through the process, you are not legally separated. But we do use those terms all the time. And I remember my brother was getting a divorce back in the late 1990s, and his marriage had really been over for quite a while, but they finally were going through the divorce process. And he finally got on Facebook for the first time, and my older brother, and I remember him working on his Facebook profile, and he wrote legally separated, and I was doing his divorce, and I said, Joe, they're legally separated. And my brother's pretty funny. He goes, what is all this legal crap we've been going through if I'm not legally separated? I said, you're going through a divorce process which hasn't been finalized. He goes, yeah, well, that makes me legally separated. No, it doesn't. For practical purposes, you can think that way if you want, but legal separation is actually an action you take with court. It's rarely done. I've done a few. It's a situation where one of the parties, or maybe both, want to clarify legal standing between the two of them, but yet remain married and have the legal identity of being able to live independent and apart from the other. The times I've done it, really two times I've been involved with a legal separation. Well, three. One was the person that wanted a legal separation needed to get support from the other spouse and needed to get child support, but she did not want a divorce from her husband. She thought there was hope for reconciliation and for potentially healing the marriage. And because she didn't want to end the marriage, she needed some legal mechanism to get some child support and to get a recognition of even maybe marital support, financial support from her husband. It really surprised me because I said, well, if you're going this far, what makes you think you can get back together? She goes, well, I don't know, but I don't want to divorce him. And there's no violence, so there's no restraining order, because you can use the restraining order tool to get child support and potentially even spousal support, and to have the right to be independent from the other person's. We call it molestation, and it's a terrible term because it suggests something wrong sexually, but we mean basically interference. You can do that through the restraining order, but sometimes the restraining order is not applicable. The other person is not violent or threatening violence or causing any kind of harm and abuse that way. They're simply not supporting the other spouse, and we need some kind of legal recognition of where the kids might reside and whether or not there's child support being payable. So you might want to seek a legal separation. That's literally what the complaint says. If you want to look up the model complaints for Massachusetts on the Massachusetts probate court forms, I'll put that link up on Blackboard soon so you can kind of thumb through the forms. It's a very form intensive area of law, which I kind of like, because I'm like, what am I going to write next? What am I going to say next? The forms kind of trigger you to write in sections that are applicable to what you're seeking. In a legal separation, you're usually looking for things about monetary support for minor children, for yourself, maybe control of the residence, and maybe have the other party move out of the residence, not because of violence, but because it's appropriate for the mental health of the parties and the well-being of the parties. That sometimes is not granted. Believe it or not, there are people that are legally separate. There are people with divorce that still live together. A whole nother issue. In the other two cases I remember having involvement, one was that she just did not want a divorce. She wanted to hold out hope that her and her husband would eventually get back together, and she didn't want to give up on that hope, and she didn't feel the kind of animosity that made her feel like the marriage was irretrievably broken down and she couldn't cite a fault ground. which we'll get into in a second. So she sought a legal separation. We got it. It helps if the other party is willing to agree, because there's defenses the other party could put up. There's no grounds for it. I am supporting the other person. We are living together. There are no fault grounds here. There's no cause to seek a legal separation from me, and they're hard to win if the other party isn't basically creating a situation of a form of desertion almost, but not wanting to have a divorce. So the other kind of sort of entity, there's probably many more. It's usually religious. I had two different clients, both female, wanted to get a legal separation and not a divorce from the husband. They were very devout Catholics, and they couldn't fathom the concept of getting a divorce. They didn't want to remarry. They didn't want to move on to a new relationship, but they wanted to end the legal commitment to the other party in abeyance. The marriage is still valid. You can dismiss a legal separation from the court at your discretion when you wish, but they needed to get child support for their dependent children and needed to get the other party kind of not coming over their house and harassing or stalking. I shouldn't say stalking because we know they can't do that anyways, but basically create that legal separation in the eyes of the court. Very rare. It doesn't come up that often. And most people that come into my office in the past that wanted a legal separation really wanted a divorce, but they thought it was just called a legal separation. It's a very narrow area. Most people, if they hit that point, they're ready for the divorce. But not all. Again, like I had 3 clients in my lifetime that wanted a legal separation, wanted to keep the marriage as a legal entity intact, but wanted to be able to create an independent state for at least a period of time and resolve some financial issues between the parties. Different than that is annulment, and there's 2 kinds of annulment. One is a religious annulment, which is the one I used to think was the only one growing up, because some people, in order to stay in good stead in their faith, depending on what their religion is, might not really be held in high regard by your church or your religious organization if you seek a divorce, because marriage is supposed to be forever unless death do you part. And if you get a divorce, you're kind of not in good standing with your faith. And so some people seek an annulment in the religious faith. That's different than a legal annulment. Sometimes you want to seek both. So this is not a religious class, but those of you that maybe are, I don't know the other faiths, I did study a lot of religion, but I know in the Catholic faith, for example, to get a religious annulment, it's basically an acknowledgement from the church that you were never married, and therefore you stay in good standing with the church and able to remarry or marry for the first time because you've never been considered to be married if the annulment is granted. And there's a petition you file with the church, and it usually costs some money. And they do an examination of whether or not it's appropriate to end the existence of the marriage as if it never had happened. And I don't know the criteria. I'm not a religious leader in that faith, so I don't know, but I know a little bit about it. The ones we're going to talk about in this class is the legal annulment, and they do exist. And some people have the false conception that anytime you've been married for a very, very short period of time, a few months, maybe a year, and you just say, boy, we really rushed into this thing. We made a mistake. We should be able to get an annulment. I can tell you for practical purposes, if both parties want an annulment and no one's really trying to take advantage of the court system, the court will often allow an annulment if both people agree upon it. But what do they have to agree? They have to agree the appropriate legal elements exist. For an annulment to occur, the marriage either had to be void or voidable. So to be void, there's only certain things that make a marriage void. It was illegal for some reason. One of the spouses was too young and it was illegal in the jurisdiction to be married. Therefore, you're eligible to get an annulment, a declaration that the marriage never existed. The second kind of situation for a void marriage would be because one of the spouses was already legally married, and therefore it would create a situation of bigamy or polygamy, and therefore the current marriage is a sham under the eyes of the law, and it's void, and therefore I should be able to get an annulment, a declaration that I was never married to this person. Those are the void kind. What are the voidable kinds? Usually it relates to material mistake of intent. So I get married to somebody. I've been married for, it doesn't matter the length. Usually it is a short term though. I've been married for a year and I find out my spouse isn't exactly the same faith as I thought she was in terms of religion, for example. And I really wanted to marry somebody within my faith. I find out she's not my faith. Once I find that out, I don't continue to engage as if I'm married. I don't continue in a marital arrangement. I don't consider to cohabitate and act as a married couple, because that would be considered to be what? Waiver or forgiveness, right? And if you forgive and or you waive the cause in which you have a right to annulment, you're no longer eligible for annulment. So early on in the marriage, you find out there's been some material mistake of fact, usually fraud, but it doesn't have to be intentional. It could also just be a material mistake of fact. In the old days, you're dating somebody, you find out one of the parties is pregnant early on, or you think they are, you get married very quickly in a ceremony, and you find out after a period of time it was a false pregnancy, they aren't pregnant at all. So are you marrying because of a material mistake of expectation? You are. That might be an eligibility for annulment. Usually it relates to a false voluntariness. You have been tricked, duped, or whether it's intentional accident. Usually we think of fraud because it makes the story more interesting, right? It doesn't always have to be fraudulent. Some material mistake of fact. And why does it usually relate to a short-term marriage? Because if you find out, usually these major mistakes, I didn't know you weren't a Catholic, I didn't know you weren't pregnant. Those things usually tend to reveal themselves in a relatively short period of time. And so obviously if they reveal them to you and you continue on as a married couple, you've deemed to have forgiven, basically you've ratified the marriage. It's no longer voidable. These are fairly rare. But why do they still exist, and why do we need to know that they exist at law? If you are successful in getting an annulment, it's a declaration by the court that you were never married. So why would you like that? Well, some people want that. They say, I don't want to say this is my second, third, fourth marriage. I want that one declared to have never existed because I never truly had the intent to enter into it, or it was illegal and therefore void. The more important thing, it usually relates to money. Because if you were never declared married, or you were declared never to have married, the other spouse can't claim any of your assets as marital assets. They can't seek alimony because you were never married. So if I had a house, I get married, and it was a very nice house, and I had a lot of equity in it. It was great. And now I'm successful in getting an annulment. My wife is no longer really my ex-wife. She has never been my wife, is the declaration. Therefore, she can't make a claim that she should have some of the equity in this house as a marital asset. We were never married. At one time in history, if you were married for a period of time, say 5 or 6 years, and you were successful in getting an annulment, the kids that were born during the marriage would become bastardized, believe it or not. That's the legal term. I don't mean to be offensive. I know it's a swear in many people's views, but that's actually a legal term for children born out of wedlock. So in theory, it would make children, but now there's statutes that say children who are born during the course of a marriage later declared to be void because of an annulment aren't deemed illegitimate. In fact, illegitimacy is no longer a significant aspect of law anywhere in Massachusetts in terms of identification for the children, because it's the children getting the stigma for that name. In fact, more than 50% of all children now born in the United States are born out of wedlock, so that stigma is completely gone. But annulment's a powerful tool in law because somebody might be at risk of losing their pension or a chunk of their home or their wealth, and they don't want that other party to get a piece of the pie. If the annulment works, and you've got to prove those grounds that there was a lack of true intent or it was void under law, if you can do that, the declaration is you were never married. And therefore, there might be some ramifications for that. It has no impact on what your faith will determine whether or not you're entitled to an annulment or not. So every so often you read about some story that someone was married for a really, really long time, and they recently got an annulment. Chances are they got a divorce in a court of law and got an annulment through the religious organization, because they go by completely different standards. Those are narrow areas of law, but I do want you to understand annulment. I do want you to understand there is a pathway called separation that gives you certain legal rights, but keeps the marriage alive in case you have religious underpinnings or philosophical underpinnings that you don't want to lose the marriage, and maybe hope for some kind of reconciliation. Annulment's a powerful tool. I've done a few annulments. Usually very, very short term. And usually they come in and say, oh my God, we met a month ago. We had this whirlwind romance and we didn't really know each other. And we got married. And then we found out we really are we hate each other. Neither of us are evil or anything like that, but we just don't want to be married. Can we get an annulment? If both parties in agreement, I usually can cite some language that someone had not known certain information about the other, or was misunderstanding about their faith or their philosophy or something like that. And if both parties agree, the court tends to let it go. But the court does make sure in the hearing that both parties know that this is a declaration the marriage never existed before. Therefore, there's no division of marital assets or no right to potentially alimony or spousal support claim. A lot of loss there. Now let's get into divorce, the fun stuff. We know, although the statistic has come down a little bit, a lot of people think that's a sign of hope that divorces are decreasing a little bit, but there's some evidence that it's still close to 50%, but it's dipped under 50. And some people argue that's because people are recognizing, the beauty of marriage and family, and they're trying to create more stable environments, and they're hopeful for that. The reality is much fewer people are marrying, and maybe those that are marrying are a little older, maybe a little bit more mature, maybe a little bit more thoughtful about it. So there might be the statistics, I don't think are only about a lot of people divorce, significant number, close to 50%. And what's shocking to me is you're more likely to get a divorce on your second marriage. You think it'd be just the opposite. You marry young, you have a 10, 15-year marriage, you guys don't like each other anymore, you get a divorce, and then a few years later you remarry. You think on the second go around, you'd probably marry somebody who, you fetter it out a little bit better. You get a better feel for compatibility. But those marriages are likely to fail closer to 70% of the time, second marriages. And it goes even up higher for the third marriage. I don't know why. I'm not a psychologist or a sociologist to understand that dynamic, but it's quite remarkable that second marriages are more likely to fail than first. You wouldn't think, at least common sense suggests to me, you wouldn't think so. So anyways, what happens when you get married? Half of us will get divorced, right? What do you do when you get divorced? Do you have to cite fault grounds? No, you don't. Up until 1974, you had to cite fault grounds. We were in a society that believed in the wholesomeness of marriage, that marriage was good for the stability of society. We didn't want people to willy-nilly get upset and say, that's it, I'm divorcing you, and just go through an easy process and get it done. We wanted parties to be able to say, I have fault with the other party that's recognized in law in order to seek a divorce. In Massachusetts, I believe there are 7 fault grounds. Some of them are no longer material. But what did we recognize? That and the divorce rate was much lower prior to 1974, and pretty much throughout the nation, right around that era in the 1970s, all the states started adopting no-fault provisions, meaning you can just divorce because you're dissatisfied, you're not happy in the relationship, a marriage, you want to end it. And that opened up the floodgates. And I believe I already posted a discussion board question that, is it a good idea to allow for divorce without fault? Shouldn't we have fault? Because otherwise people can just say, this guy or this gal, not so great. I can do better. I'm just going to get a divorce. Can you? Yeah, you can. You don't have to cite fault anymore. But why should we know about the fault grounds? Because when we get to the later chapters, fault, you've done something wrong by your own decision, arguably. And that wrongfulness should be considered when we divide the marital estate, and it should be considered when we maybe give child custody, and maybe those fault grounds should be considered whether or not someone either gets alimony or how much they should pay in alimony, spousal support. I can tell you right now, the fault grounds don't do nearly as much as people think they do, especially some of the, I'll go through the classics. Many relationships sadly end because of adultery. People are cheating. No longer, unlike many of the websites I see for divorce attorneys, suggest that adultery is a valid ground. Yes, it is. It's in the statute that you can cite adultery as a fault ground, but you have to prove the other party had consensual sexual intercourse with another party, not just innuendo. We all know what happens. You see your spouse go to the casino, you follow them there, they go up to a hotel room, they sleep overnight, they come out disheveled the next day holding hands. We kind of know what happened, right? But that's not enough proof. You've got a lot more to prove, and you've got to name that adulterer in the mix as a third-party defendant. It's very difficult to prove adultery. In courts now, and I probably will test you on it, will not benefit the victim for greater access to child support or the division of marital assets just simply because the other spouse is a cheat. And a lot of us have mixed views about that. I say, wait a minute. I'm representing Jane. She's an innocent spouse. She's done nothing wrong. Her husband, Joe, is cheating on her. He's a really bad husband. He's been disloyal. And now the marriage is no longer going to be viable as a result. Jane wants a divorce. She wants to keep the marital home. She wants Joe to pay some spousal support for a period of time. And she wants custody from this no good cheat. Some people think that evidence should be used to help determine those other questions about the marital home, about the custody of the kids, about how much support she should get. The laws in Massachusetts, or the courts in Massachusetts, have generally rejected that theme. In Massachusetts, it's called failure of the heart. Somebody having an affair is not going to lose their right to the equitable distribution of property. they're not going to be deemed an unfit parent because they're a cheater, and they're not going to have to pay more or not be eligible for alimony simply because they're a cheater. It's kind of almost irrelevant now. I know that sounds terrible because I don't do divorce work so much anymore, but I get people coming. It's a common reason because my husband or my wife is cheating on me. I'm really horrified, and that's why I want to have a divorce. And I say, well, let's file for divorce for irretrievable breakdown. And I said, well, no, I want to file for adultery. Isn't that one of the fault grounds? I said we can, but the court often deters us from doing so because there's no real benefit in Massachusetts to get a bigger piece of the marital estate. You think there should be, but there's not. I'm telling you, the courts have made a very strong conclusion that unless it's really designed like you're cheating in front of the other spouse to hurt them emotionally, you're committing really, it's not just a failure of the heart, it's really barbaric cruelty to the other spouse by, flaunting the other mistress or I don't know what you call them, the other adulterer with you. Most people that are cheating are doing so somewhat discreetly. They get caught though, however. That's not going to affect their slice of the marital assets later on. It's not going to affect their child custody, believe it or not. And it's not going to affect how much they pay in child support, nor is it going to impact whether or not they can receive or should pay alimony, which we haven't got to yet. I mean, it's a later chapter, but I just want you to know there's no real advantage to citing adultery except what? Well, think about it. If you've been cheated on and you want to go to court and say, hey, I'm not the one that threw out this marriage. He or she is. They're the one that cheated. I want the court to know why. And so what I often do is if they're very, very adamant about it, I will cite adultery as the grounds, but I'll also seek divorce for the alternative ground of irretrievable breakdown. I make sure my client really wants a divorce. And I say, I'll go for it. But I can tell you the court would they get closer. Why? One is if you're citing a grounds like alimony, you're going to tell the court that this other person's a bad person. It creates a lot of acrimony during the process, hard to come to agreement on things. And you have to prove these very salacious, damning things in a court of law. And guess what? It's an open record. Your neighbors can know about it. The kids can open up these files and learn about what mom or dad had allegedly done. Courts don't want to see that. It's better just to cite irretrievable breakdown. And we're often encouraged to amend the complaint. I don't have to amend the complaint because I cite two different grounds: adultery and irretrievable breakdown of marriage. Adultery is no longer a crime in Massachusetts. It was a felony until recently, but no one's been charged probably for 100 years in Massachusetts with adultery. I used to have a joke like that because I was friendly with still friendly with many assistant district attorneys. But every so often I meet one that was a bit of too much of a zealot. Jim, if you ever know of any crime, you can always tell me and I can bring it to the grand jury. And I'm like, I know of a few people cheating on their spouses, I'd say. And they'd say, get away from me. Not because they didn't prosecute it. It's called a law that fell into a swayitude. We recognize these things happen all the time, and the law was ignored. And recently, in 2018, I think it took effect 2019, adultery was removed from the books as a crime. No longer is it a criminal act to cheat on your spouse. And some people can say that's awful. It should be a crime. I'm not here to determine whether the law is right or wrong. I'm just saying it's no longer a crime in Massachusetts. It was a felony up until 2 years ago. Now it's off the books because we just recognize too many people get involved in it. And they're not necessarily doing evil things, and the court of criminal law shouldn't be involved in it. So that's one of the big ones, adultery. Might as well talk about the one that's the main one. What's the main fault ground that people cite for divorce? In Massachusetts, called cruel and abusive treatment. It doesn't always amount to criminal treatment. It's either one major, usually violent event against the other spouse, but more likely it's a pattern of cold disdain and abusive conduct, words and deeds that make any reasonable recipient feel hurt emotionally and maybe even physically, such that it kind of shocks the conscience, and therefore the court will grant a divorce for cruel and abusive treatment. Again, the courts don't really like it if we're going to have that because we have to prove the other party did these terrible, called me all kinds of names, humiliated me, it made me feel like crap, yelling all the time, throwing my clothes out in the front yard. Who knows what kind of nutty thing people do to each other to be cruel and abusive. But if you can imagine it, it's happened. I could tell you many war stories I've heard, and I think about, I'm divorced one time and I just think, we look like we've freaking got along great compared to some of what these other people do to each other in the course of the marriage, creating a real objective degree of wrong. And both can be responsible. For example, you get one party file a complaint for cruel and abusive, and what's their answer? A counterclaim, also for a divorce for cruel and abusive treatment, because both have been terrible to each other. In the book, I outline some good information of what does it mean to be cruel and abusive. It has to be pretty heinous over time. Usually one incident is not enough. It's going to be a pattern of behavior that leaves an objective observer with a sense that this could impact their health emotionally and physically, and it's unlikely to change. Why do we still cite it? Well, one party doesn't want to go in and say it's not because of irretrievable breakdown. It's because he or she is cruel and abusive. I want the world to know. I want my day in court. But more importantly, this does impact who's likely to get custody, because we don't want to give it to a cruel and abusive person because chances are they're not the better parent. Not always, but at least on its face, it gives you an advantage. The other is the victim of cruel and abusive treatment probably, maybe, arguably, should get a bigger piece of the marital estate when we decide to split that up. How it will be to split up. The wrongdoer should get less, the victim should get more. And the same with potentially for alimony. So cruel and abusive treatment is still alive and well as a fault ground, still the biggest ground cited. It's also fairly, I don't want to say easy to defend, but you've got to prove these elements and you've got to bring witnesses in. It can be very challenging. And oftentimes, I hate to say it, the victim of cruel and abusive treatment often retorts to cruel and abusive treatment themselves. It just becomes a relationship of acrimony and hatred. Welcome to the world of divorce law. It's tough. But that's the biggest one. Now, the minor ones, one that is not cited anymore at all is impotency, the failure to have the ability to enter into sexual relations. It's still in the books. No one ever cites it because you don't get any advantage by saying my spouse can't or won't. It's sometimes called they are resistant to entering into sexual relations. That is a fault. You can cite it, but it doesn't give you any advantage on a division of marital assets, custody, or anything like that. So why bother going? It's just designed to humiliate the other party. You shouldn't do it. So I don't know anybody that cites that as a fault ground, impotency or the failure to engage in sexual relations. That might be the reason, but why cite it? Cite irretrievable breakdown, which I'll get to in a second. So I've gone through 3. Utter desertion, still somewhat of a big one. There you have to meet a lot of elements. The defendant, the one that is being sued for divorce, has to have been away, basically abandoned the other party, for at least 1 year before the filing of the complaint. And it has to be without just cause and without the expectation of return. So if I'm saying, hey, I just got deployed, I'm going to be away for 12 months and I'm going to be over in the Middle East, well, that's not voluntary. That's because it's a government commitment. And there is an expectation of returning, and it is for a just cause. So utter desertion wouldn't work there. But what if after an argument or whatever, or we haven't been getting along, I just one day get my knapsack and I leave the house, and a year's gone by, my wife would have every right to seek a divorce for utter desertion. Clearly gives her an advantage for custody of the kids. I've been gone for a year. I'm not obviously the ideal parent if I just disappeared if we have kids together. Secondly, she should get a bigger piece of the marital estate, because that's a wrongdoing. You don't just want to abandon people for a full year. Now, careful. One of the defenses to it, it was with just ground. She was chasing me out of the house with a frying pan. That's why I left. Then utter desertion wouldn't work for the other party because it is a justifiable leaving of the marriage relationship because of violence. But utter desertion still exists. It's still pretty prevalent. Another one, not rarely used, but you'd think it could be used a lot because, let's face it, it's significant in our society. And it's being a chronic alcoholic or drug addict. And I mean chronic, meaning it can't be like, oh, this person got really drunk one Saturday and, was walking around the house at a party with a lampshade and embarrassed the hell out of me. I want a divorce. Well, seek a divorce if you want, but don't seek it for that ground of being a chronic drug or alcohol abuser. And it has to be chronic. It can't be just an occasional drinker or an occasional drug user. It has to be fairly significant. And it's sad that that's a big part of our culture. I don't care what anybody says. I'm mostly a criminal defense attorney now. Many people involved in the justice system are there because of alcohol and drugs. There's just no question about it. But you can think about it. If you're married to somebody and they're chronically abusing alcohol or drugs, should it be a ground for you to be able to end the marriage? And our society in Massachusetts certainly says so. That's one of the major grounds. You have to prove it, though. It's got to be involuntary. So what if my spouse is saying, my spouse is on all kinds of opiates every day, and I've had enough, and I want a divorce? What if my spouse comes and goes, yeah, I have a very rare terminal or disease, and the only thing that keeps me alive and out of pain is by taking prescribed opiate-based medicines. Well, therefore, that'd be considered involuntary, and it would be an inappropriate use of the statute. You get what the statute's for. It's when somebody's abusing it wrongfully and for a longer period of time than just, I don't want to call it recreational. I don't know who does recreational abuse of things, but you get my drift, I think, on that one. I don't even know if that one's in the book. It's one of the causes in this book, but it is certainly in Massachusetts. You know, we got adultery in the book. We have desertion, which in Massachusetts we call it utter desertion. We talked about cruelty. Yeah, and they don't even bring up the other ones in Mass. Again, the other one in Mass, drugs and alcohol. And the next one in Mass is a state prison sentence of 5 years or more. You should be able to cite as a fault ground that the other party is incarcerated for 5 years as a result of the sentence. It gives you the right to seek a fault ground divorce, gives you an advantage in the division of marital assets, and also gives you an advantage, obviously, in custody of minor children between the couple. Okay. What are the defenses? Well, forgiveness, recrimination, conniving. That the other party was basically, my husband told me to go out and cheat. It was one of those weird kind of relationships. Obviously, you can't benefit from something you gave consent to, and you can't benefit from something that you're complicit with. Common sense, I think, for the most part. And you can also always counter sue. I've had clients come in and say, my wife is suing me, my husband's suing me for, divorce for cruel and abusive. Let me tell you what he or she does to me. I'll say, relax. They have to prove their case. Do you want a divorce? And most people at that point also want a divorce. So we file our answer along with a counterclaim seeking divorce for the same grounds. And sometimes you'll see in a newspaper on Sunday, and there's a little legal section. You can see, divorce is granted. And sometimes you'll see, Joe Smith from Jane Smith and Jane Smith from Joe Smith. They both had their divorces. I mean, it's kind of semantics, but it's kind of interesting when that comes up. So those are the fault grounds. The fault grounds are the smaller group of divorce actions. I'm not saying they're not the reasons. The main one that we do now since 1974 in Massachusetts and throughout the country is something called no-fault divorce, or the irretrievable breakdown of the marriage. In Massachusetts, again, when you file a simple affidavit, there's like classic language to say, my spouse and I have developed different goals, philosophies, and outlooks on the best way to live our lives, and our marriage has become irretrievably broken down, and there's no hope for reconciliation. We've had enough. In the court, at one time, there was like a waiting period. You had to live apart for a period of time. Not anymore. You can still be living together and seek a divorce. It's bizarre, but people do, because especially with economic times, neither of us can afford to get our own place. We're still an economic team, but she's going to live upstairs, we're going to live downstairs, but we just want to be divorced. Stranger things have happened. The world's a strange place, isn't it? But no fault. You don't have to cite any fault. And the reason why in 1974 they did it, a lot of couples were actually perjuring themselves. They come to court, they're decent people, but they really just hate each other. But they're both decent human beings. They realize they made a mistake. They're not eligible. It's not the kind of mistake that allow for an annulment. So they want a divorce. Well, back before you could cite no fault, what did you cite? You say, geez, I hate you, you hate me, but neither of us are cruel and abusive. Neither of us are a chronic alcoholic or drug addict. Neither of us are committed to 5 years. We're not committing adulterous acts. What can we do? Let's lie. I'll admit that I'm cruel and abusive to you, and I've called you lots of names, and I've been terrible, and I've stayed out all night, and I've, just did terrible. Like, I cut up your clothes with a pair of scissors because I wanted to humiliate you. I don't know. I'll say I did those things because I want a divorce, you want a divorce. We'll go perjure ourselves before court of law, and that was pretty rampant. We didn't want people to have to do that, and basically our society has said, at least in Massachusetts since 1974, and most states since the 70s, got to let people divorce who are miserable with one another. And that opened up the floodgates. And the divorce rate's now hovering around 50%, significant numbers. People get divorced, but they shouldn't have to stay together. It's fairly easy to get a divorce. Well, I say easy. I'm doing one of the easiest divorces I've ever had, and it's still a freaking nightmare. People arguing over money and who's going to keep what. And they don't even have any kids. It's not that easy. But no fault. You don't have to, and it doesn't have to be, one party can say, I have a different philosophy, goals, and outlooks as my wife does. And what if my wife says, no, I don't. I'm still crazy in love with Jim. I want to stay married. Can she defeat the divorce? Well, she'd have to argue certain defenses like I'm lying or I'm perjuring myself or something like that. But if one person wants a divorce, the marriage can end. The other party can't force the other party to stay in a relationship they don't want to. The difference is if both parties agree to get the divorce, it's a much quicker process. It's called a joint petition. We'll get into that later when we do pleadings, as opposed to a complaint where the other party can raise defenses, arguably, and things of that nature. So that really opened up the divorce whole ball of wax. There's a thing in the book, and it's fun for some people. It's called a covenant marriage. I don't know where they do it other than Louisiana, but there you can contractually agree to marry your spouse in a covenant marriage that requires you to take premarital counseling. Many of you do that because of your religious practices. But in order to get a divorce, you agree ahead of time the only way you'll get a divorce is if there's a valid fault ground, and you have to seek counseling before you get a divorce. Well, anybody on the eve of divorce says, "Oh, that sounds wonderful," because we never intended. No one goes into a marriage expecting to get a divorce. But boy, when they want a divorce later, they got to really jump through some hurdles. And I don't think it's really caught on a big wave throughout the United States to enter into a covenant marriage. Most marriages are fairly easily dissolved. I'm just looking at some of the other consequences of divorce. Okay, the action, the separation. So the covenant marriage exists in some states. Most do not. You do not have to live apart en masse to get your divorce, which is bizarre. For a while you had to. And the critics of no fault saying it's just too easy. I could be the greatest guy. I don't know if the greatest guy in the world. I could be a really great husband. I'm supportive financially. I'm supportive emotionally. I care about my wife. I'm loyal. I pick up my socks. I do whatever I'm supposed to do as a spouse. And my wife says, "I just don't like you anymore," or I met somebody new. Can she divorce me? Yeah, no fault means no fault. There's nobody at fault. It's not your fault, not my fault. I'm just done with you. A lot of people say that's unfair. There should be a fault ground. And that philosophical argument still goes out but there's no turning back. People are going to be eligible to divorce them because they want to move on from relationships. And some people think that's awful. Other people's in our courts have recognized and our legislatures recognize people shouldn't be required to be miserable. I don't do divorce too much anymore, but occasionally I have friends come in. I'll do one for them if there's not kids, because the ones with kids last forever. And sometimes they're really shocked that the other party wants a divorce. And at first I'm like, oh, they seem angry, and I can't wait for this divorce. I can't wait to get rid of him or her. I can't believe they, are so bad to me. And then in the middle of it, they break down because I grew up with them or I knew them, and they say, I can't believe he or she doesn't want to be married to me, because all of a sudden they said, you don't really want a divorce, do you? They'll say no. And I'm like, well, there's nothing legally I can do to make the other side come around and realize this is a mistake. And it really saddens me because many times both parties want a divorce. I don't want to call it a happy divorce, but both parties want out. But there's a lot of times where only one party wants out of the divorce and the other one's heartbroken. Nothing I can do for you. And one of the things the book doesn't get into, but it's from an earlier chapter, one of the defense grounds of a valid marriage is to try to argue that, well, in order to get a divorce, you have to be validly married. And you try to argue there was no valid marriage because it's a breach of contract. You can't sue for breach of contract in marriage. Even though marriage is a contract, you can't say my spouse is leaving me without good cause, so she's breaching a contract. I'm going to sue for financial damages. It can't. It's barred in every state in the union that I know of. I know Massachusetts has a special statute called the heart bomb statute. You can't sue over having your heart broken in a failed marriage. And that's trouble some people, like, because it's during the engagement period. Maybe one party has rented the hall and hired the band and paid for the person to do the ceremony and spent a ton of money, maybe on a honeymoon vacation and all that kinds of stuff. And the other party just wrongfully jilts the other party at the wedding. Can you sue for damages? No, you can't. Even though you've done nothing wrong and the other party has done everything wrong, the law simply bars lawsuits over being crushed with the breakup of the marriage. I've been all over the place with this review, but I hope you get the nature of basic divorce question. The chapter is very well written. Hopefully the homework assignment is pretty clear. I know some of you have chapter 6. The most recent edition of the book, I was trying to use chapter or the 6th edition to save everyone money, but the bookstore never orders that because it doesn't make any money from the bookstore. But it's pretty much the same questions, and it just might be falling on a different page. And if it is different, I have both editions. I'll try to make sure it jives. The next chapter is really big. So any questions or concerns, don't be afraid or hesitate to call me or contact me. Thanks.